Hello, I'm attorney Lewis Haskell. Today is Saturday, March 6, 2021, and I really want to talk today about the employee retention tax credit. We're now well into tax season. I've had the opportunity to talk to many of my clients, and very few of them have been using or taking advantage of the employee retention tax credit, probably because it's very complicated, probably because it's misunderstood, and largely because most people believe that they're not eligible for it because they receive PPP loans. In its original form, which is to say, is in its CARES Act form, yeah, the employee retention tax credit was not particularly useful, in part because the benefits weren't that great, and in part because you could not take both the employee retention tax credit and a PPP loan. However, when they passed the last stimulus bill, which maybe next week will be the next to the last stimulus bill, but the one in December, the Comprehensive Appropriations Act, they changed the rules on the employee retention tax credit, and they changed them very significantly. Perhaps the most significant change was that they got rid of that mutual exclusivity between the employee retention tax credit and the PPP, so that it is possible now to have received a PPP loan and also to take the employee retention tax credit. The only catch is, and it does make things a little bit complicated when you're actually, filling out the forms, is that you cannot take an employee retention tax credit on wages you paid by means of the PPP. So that that can be a little bit tricky, but that does make it a good benefit again. And at the end of the day, that exclusion is probably not so important because the employee retention tax credit in 2020, which is to say under its CARES Act form, was restricted to 50% of wages up to $10,000 for any given employee, meaning that for any given employee, the maximum tax credit for the entire year was $5,000, and and again, wages in excess of 10,000 for the year, or at least for the for the year. So for all the quarters you're involved in 2020, can't exceed 10,000. So for many employers, who would be eligible for the earning employee retention tax credit for 2 or 3 quarters at least, some for the entire year, uh, most of their employees are maxing out even after you deduct PPP expenses, and those who aren't didn't receive a lot of PPP money anyway. So that becomes less of an issue. Where it becomes a huge issue is in 2021 because although the tax credit was supposed to expire on December 31, with the Comprehensive Appropriations Act, the December stimulus, they extended that to June 30, 2021. On top of that, they increased the benefit to be 70%, up from 50%, but 70% with a cap of $10,000 of wages per employee per quarter. So anybody who is eligible for the employee retention tax credit can now deduct up to $7,000 per employee per quarter. And since there's 2 quarters of 2021 in play, that would mean up to $14,000 as opposed in 2021, as opposed to the 5,000 for dollar cap for 2020. One of the reasons I want to talk about this today, though, is that the IRS has put out long-awaited guidance on the employee retention tax credit. It is interesting that this thing has been in place now for close to a year, and the IRS is finally has a publication out telling us about things. One thing that we've always known about the employee retention tax credit was that you could get it if you saw a 50% drop in revenue in one quarter of 2020 versus the same quarter in 2019. I have to pause for a moment. I apologize. So I was saying that we've known since the CARES Act that for anyone who experienced a 50% drop in revenue um, in comparable quarters year over year would be eligible for this credit. Now, what does that mean in English? Imagine that you're in a business such as, say, a nail salon or a beauty parlor, and in the first quarter of 2020, people stopped coming in. Now, you eventually shut down on March 17th, but before that, business had dropped considerably, and of course, after March 17, you were shut down, such that you made, in terms of gross revenue, 50% less income in the first quarter of 2020 than you did in the first quarter of 2019. That would qualify you for the employee retention tax credit. And you would stay qualified so long as revenue in, in subsequent quarters is down 20%. Now, in this example, of course, the second quarter would have been a disaster for you because you were shut down really for almost all of it. But then the third quarter, that's July to September, was probably not very good either, even though um, actually nail salons weren't open until sometime in July. Um, but say you're in a business that could reopen in June, so you're open that quarter, but revenue is still down because people are afraid, and and on and on. As long as you keep that 20% drop in revenue, you can keep that um, employee retention tax credit going right through June of 2021. So that is fairly straightforward. And by the way, you can keep it until the quarter after. So if you have a good first quarter of 2021, and in the example I just gave, you may find that your revenue actually goes up in the first quarter of 2021, so that you lose it. Um, you still get to claim it into the next quarter. Yeah, you still get to claim it into the next quarter. So you're golden. Now, um, there is, however, another group of people who we know qualify for the employee retention tax credit, and those who have been shut down by the governor. So again, if nothing else, um, the nail salons and whatnot get a period of employee retention tax credit because of the shutdown that they experienced. But there's also a more ambiguous piece of this, which is the partial shutdown. And it's in this area that the IRS guidance is more useful because it gives examples. Um, and I suppose the best example involves restaurants. Uh, Restaurants weren't shut down per se. They could still do carry out. There was a period of time where they could still do outdoor dining. But for most restaurants, most of their money is made in indoor dining. And so, so the IRS guidance makes clear that since that's such an important part of their business, shutting it down made them partially shut down, and thus eligible for the employee retention tax credit. Where it gets more interesting, though, is if you have what's essentially a carryout, but has some uh, sit down indoor dining. Um, think about Starbucks, for example, but here in our community, we have a lot of coffee shops, a lot of sandwich shops, a number of places where most people carry out, but there's still one or two tables set up, and for people to sit down and eat. And there, it's very ambiguous. And the IRS says so long as it's not nominal, what they're not allowed to do anymore. And they define nominal as being responsible for either 10% of your revenue or 10% of your, kind of employee hours. And in fact, in the case of the, carry out one or two tables, if there's a server in that place, if there's somebody whose primary responsibility is taking care of those tables, you probably meet the 10% standard pretty easily. Otherwise, you really do have to go back and try to figure out um, how much of your revenue or how much of your time is spent dealing with these people who actually stay and eat on premises, and how much of your revenue or how much of your time is dedicated to everything else. Um, for a lot of very small businesses, that's going to be basically the honor system. Um, if you, for example, if you charge same for a sandwich or for a cup of coffee, whether it's eaten on premises or carried out, your cash registers probably aren't going to tell you what's in house and what's out. So that gets to be, a fairly difficult thing to document. Um, but 10% is also a low threshold. So I would imagine even there that anybody who does have a reasonable sit down business would qualify. Where the IRS gets mean is for uh, people like me. I First of all, I was not ever on a shutdown order, both as an attorney and as a tax preparer. I was declared essential, if you can believe that. But it's kind of touching that the governor thinks that us lawyers are essential people. So good for us, but bad for us here because by virtue of being essential, I don't get any benefit of being declared in shutdown. And on top of that, the IRS would go on and say, even if I we're able to telecommute, and they talk a lot about that. In fact, the IRS has said, even if it takes me 2 weeks to convert my office to a remote office, that's still not a partial shutdown. So I don't know what I did to make them so angry, but and then they say, in the fact that people weren't coming in, and frankly, from that period, March 17 through April through May, I mean, we were open, but we had essentially no foot traffic. Um, the IRS just says, well, if people being afraid to come in is enough to get you to that 50% drop in revenue point, you qualify that way. But the fact that it was the middle of tax season and people stopped coming into the office uh, doesn't by itself qualify you. You are not considered to be in partial shutdown. So really, there are places where I think um, you could be, well, no, there isn't, because actually the IRS has said, even if you voluntarily shut down to be, in the spirit of the governor's orders to comply with CDC guidelines, that kind of a thing, the IRS says that's your choice. And again, unless you meet that 50% revenue threshold, you are not in the shutdown category. So, what I'd say is this is complicated stuff. We're here to help people who need some help with this. Um, the paperwork requirements, especially with the PPP interfaces, are kind of nasty, and so we're available to help with that as well. Um, but mostly, I just want people to know that this is a great opportunity to retain staff, to take on staff for projects that you may not have been thinking about or ready to operate on. And so until then, I urge everyone to please stay safe and stay strong. And I look forward to seeing you soon.